this point, because it happens to be her third offense related to I'm having trouble seeing that they're related offenses. I really am, other than the fact that they're motorized vehicles.
Right. Well, the appellant would submit that again there is no distinction, and the discretion on the police would be there in the event, in the actual circumstances as it's happening. But the police in this case had to try with some difficulty to actually get her to pull over. They had their lights on and the sirens on. She didn't hear. One of the officers had to jump out of the car and chase her down on foot to stop her, which would suggest a reasonable speed. And the officers in that case would have seen a risk of danger and chose to pursue the charge. So the discretion on their end, the situation was such that they thought it was necessary to place a charge. In that sense, the discretion should be no different on the event of the trial judge. The trial judge found that the fact that she had actually committed the offense was not in dispute. What is in dispute is the cruel and unusual nature, if there is one, of the mandatory minimum sentence of 120 days in prison. I would just conclude the application of the Latimer factors. This is at paragraph 31 of the appellant's submission. The appellant submits that a mandatory minimum sentence will only be so grossly disproportionate that it violates Section 12 of the Charter on rare and unique occasions. The circumstances of Mrs. Smith are not such an occasion. So we find that there is no Section 12 violation. However, if there were a violation, we'd be able to justify it under Section 1 of the Charter. Here it is clear that the purpose of Section 253 is to protect the public from the harms of drunk driving.
Counsel, I'm just, maybe my charter jurisprudence really isn't up to scratch, but if there's been an exemption, constitutional exemption from the particular provision on constitutional grounds, have there been cases in which the court has said, well, this is so cruel and unusual that we're going to exempt in this case, and yet we're going to reverse the exemption once we get to Section 1? Have there ever been any cases like that? I understood Section 1 to be addressed at saving an entire provision, not an exemption.
Well, how it would work in this case, Justice, is that if there were a Section 12 violation, you'd use Section 1 then to find if that violation was justifiable.
But my question is, has there been a previous case reversing the constitutional exemption on the basis of Section 1? Not merely because we might have an issue as to whether the mandatory minimum sentence itself is unconstitutional, in which case I can certainly understand that being saved by Section 1. But is there a prior case in which the application of an exemption has then been saved by Section 1?
Within the research of the appellants, we're not aware and are fairly confident there's no case, at least at this level of court, where a trial judge has applied a constitutional exemption from a... Are
you aware of any case at any level?
No. But in this case, the constitutional exemption is applied after the failure of the Section 1 analysis, of the Oates analysis. So it wouldn't become an issue until we found whether or not it's a justifiable limit on the right. So there would be no court that would have applied the constitutional exemption before the Section 1 analysis had taken place. Although thinking of cases where it has been applied after, then there has been no constitutional exemption that we're aware of. Justices, I'll just provide some quick conclusionary remarks. The appellants submit that the mandatory minimum sentence imposed does not violate Mrs. Smith's Section 12 charter right. Such a violation will be found only on rare and unique occasions. This is not such an occasion, as the particular circumstances of Mrs. Smith's case do not satisfy the stringent factors compiled in Latimer. The sentence imposed is not so grossly disproportionate that it constitutes cruel and unusual punishment. However, if the court were to find that Mrs. Smith's Section 12 right was violated, the violation would be a reasonable limitation justifiable under Section 1 of the Charter.
Counsel, I'm going to ask you and this is, I recognize this is going to be a tough question, but is there any situation that you could foresee where it would be such a departure from the norm that it would be a Section 12 violation? Like, isn't this the rare exception? Like, isn't this, we have a woman who drove twice. If she'd driven again in a car, clearly she's going to jail. But in this instance, she's now in a wheelchair. She has no option but to be in that wheelchair. Is there any, how much further does this need to go before the Crown is willing to accept that this is a cruel and unusual punishment?
Well, Just to that, I'd raise the case of Nazagalawa. In that case, the same issue was decided on. Justices, would it be all right if I had a couple more minutes, or shall I?
You can answer. I know that we discussed having a strict policy, but I asked the question, so you can answer my question. I think.
Sure. The case of Nazagalawa, it was quite a very unique circumstance where an RCMP officer pulled over a drunk driver. In that case, there was some trouble getting him to respond. He ended up punching him twice in the face. He had him on the ground. There was quite a bit of force applied. He broke 2 ribs. His lung was punctured. And in that case, the accused was still not found to be in a situation that was so rare and unique that they would apply a constitutional exemption. So I would just offer that as an example of the case.
You feel that that's analogous, like, you know, in this case we have a before and an after, and in that case there is no before and after. There's just a police officer that overstepped his bounds, broke a rib, and so that, you know, was the punishment appropriate?
We would say that just the case is so, it's such a serious situation that it would be analogous in the sense that it was an extremely rare and unique occasion, and even there they weren't able to say that Section 12 was violated in upholding the mandatory minimum. If the justices have no further questions, my co-counsel will now argue the appellant's second issue, which should help answer some of your constitutional exemption questions.
Thank you, counsel.
Good morning, Justices. I'm Andrea McMenamin, and I'll be arguing the second issue for the appellants, which is that if of Section 12 charter breach were found, a constitutional exemption to all users of motorized wheelchairs is not the appropriate remedy. I will just take a quick roadmap through the arguments I'll be making, and then I'll go into it in more detail. So first of all, if the provision under Section 253 of the Criminal Code is found in violation of a Section 12 charter right, the provision should be struck out under Section 52(1) of the Constitution Act. A constitutional exemption to all users of motorized wheelchairs is not the appropriate remedy. The circumstances of Mrs. Smith's
Counsel,
case...
if I can interrupt you right at the outset here, but there's an obvious third alternative, which is constitutional exemption for Mrs. Smith in particular.
Yes, that is an option, but the circumstances of Mrs. Smith's case are not so rare and unique, or the behavior is not so outrageous that she is deserving of a constitutional exemption on a standalone basis.
Well, if we get to this part of your submissions, we've already decided that there was a constitutional violation. Because if there's no constitutional violation, then your arguments as to the remedy are moot. So the question is, assuming that there was a constitutional violation here, what's the appropriate remedy? And you suggested the appropriate remedy is to strike down the section.
Yes, and
The only remedy, if I follow your argument, the only remedy is to strike down the section. Is that what you're saying?
according to the case law in Ferguson, that would be the appropriate remedy. Section 52 of the Constitution Act 1982 and Section 12 of the Charter have two different, or sorry, Section 24 of the Charter have two separate roles. So Section 52 is put in place in order to remedy when a law is infringing on a person's charter rights, and Section 24 is put in place when a government actor or an agent who is acting on behalf of the law.
But didn't they, even in Ferguson, didn't they even provide that there are options? Like even in Ferguson, which was the hard line, I get that things have changed since, but even in Ferguson, didn't was it Justice McLaughlin? Anyway, say, well, there are possibly circumstances where a constitutional exemption would be appropriate. Didn't she even leave that door open? Isn't that what you argue in your brief?
The window is left open for a standalone remedy, yes. However, it was suggested, or sorry, it was decided by the majority in Corbier, which is also discussed in Ferguson, that a standalone remedy, they refused to provide a standalone remedy in that case. And it has been strongly discouraged by the majority of Supreme Court decisions.
But it's still a remedy available to this court, isn't it?
It is a remedy that's available to this court, and as yet has not been applied. And as my co-counsel has put forth, the court in Nassau-Galloway decided that a constitutional exemption was not available, in that even though, as you can see, the police officer's behavior in that case was very forceful. They were found to be using an excessive force, but still not so egregious as to warrant use of a constitutional exemption. Turning to paragraph 41 of the appellant's backdown, the court would not strike down the section under the criminal code as unconstitutional because of its strong implications to the protection of society and how frequently it is used. While the court did leave a small window where constitutional exemption could be applied in unique and rare circumstances, if Mrs. Smith's case is distinguished as such a unique and rare case, it is also distinct from the circumstances of all users of motorized wheelchairs. Engaging in social drinking is not a fundamental right and freedom, it is a privilege. It is expected that persons who engage in such activity do so in a socially responsible manner. The pattern of behavior that Mrs. Smith has exhibited is antisocial and poses a risk to her own safety and to the safety of others. If an exemption were given to all users of motorized wheelchairs to engage in such behavior, it would significantly increase the danger to other pedestrians and all users of motorized vehicles. And the
I'm going to interrupt you there, counsel. Where do you see that like the risk you're describing? Is that a real? Doesn't the, you know, if this exemption is granted, and I'm not saying that's what we're ruling, but if the exemption is granted and people who are in motorized wheelchairs aren't subject to mandatory minimums, there's still, you know, it just leaves the discretion in the hands of the judges, right? If we're dealing with a Section 250, like, you know, the punishment here, the maximum punishment is, if it's a summary conviction, is 18 months in prison. Indictable is 5 years in prison. So if we have somebody rampantly driving around in their wheelchair and cause injury or harm or something to others repeatedly, doesn't the discretion still lie in the trial judge's hands?
Trial judges do have the discretion to impose the appropriate sentence. And in a case of Mrs. Smith, they would also have the opportunity to impose it as a community sentence, so she could serve it in the community rather than serve it in an institution. However, the trial judges don't have the discretion to limit or refuse to impose mandatory minimum sentences.
That's not what I'm asking you. What you said is that if we allow this exemption, then there's a real risk that people in motorized wheelchairs will kind of run rampant and get away with it. And what I'm saying is that if someone's repeatedly before the court with similar offenses, doesn't the trial judge still have the ability to send that person to jail for up to 5 years if the Crown chooses to proceed indictably?
While that may be true, it is not appropriate to provide a constitutional exemption where a hypothetical charter breach may exist to users of motorized wheelchairs.
But we know, if we're at this point of the argument, we know that there's been a charter breach.
In the case of Mrs. Smith,
In the
yes.
case of Mrs. Smith.
But
so maybe Mrs. Smith just illustrates, and maybe this wasn't apparent before when the law was the mandatory minimum was considered in the context of motor vehicle accidents. Mrs. Smith illustrates that there really is a problem with this law that hadn't been recognized before. Maybe we should strike down the law in its entirety and ask if we accept your argument, and I take it that Latimer or Ferguson does indicate that the individualized remedies to be rarely used, but maybe this case simply illustrates that the whole law should be struck down, send it back to the legislature to tailor the law more readily to avoid these kind of breaches. If your submission is that we can't remedy the breach on an individualized basis, maybe we should send it back.
If that is the case, that is not the same as issuing a constitutional exemption to all users of motorized wheelchairs from Section 253 of the Criminal Code.
No, but my suggestion is that the logic of your argument suggests that if we've decided Mrs. Smith her rights have been violated, we should strike down the provision.
The law is too important to strike down this provision and the implications it has on.
Well, you're just trying to put us in a squeeze here. You say, well, of course it's very important. Drunk driving generally is important. It's not important in this case, it's actually a charter violation, where you're saying we can't give her a remedy because our only remedy is to strike down the whole law and the law's too important, so we've just got to live with a breach of her rights, because we've acknowledged it's a breach of her rights. I mean, surely that just illustrates if the law really is that important, this is one of those cases where we should have a specified injunction. Otherwise, you're saying we just have to accept her rights are violated, because that's, you know, at this point, her rights are violated. We've decided that, and we just got to live with it.
The appellant submits that there is a way to impose the mandatory minimum sentence without infringing on Mrs. Smith's charter rights. The charter right in question is not formed based on the fact alone that Mrs. Smith is physically disabled and confined to a wheelchair. Those are the particular circumstances of the case, that if there were a Section 12 charter breach, it's formed at the very last step, because her third infraction was formed when she was in a wheelchair, but her previous charges under this section, she was not. And it still forms the case that she is exhibiting antisocial behavior that this section was put in place to curb.
But her rights have still been violated. Her charter rights are violated, and there's no remedy. That's your submission.
The remedy, if used at all, should be done on a standalone basis. However, the appellant submits that there has been no violation of Mrs. Smith's rights in this case.
Maybe I can. What my brother Justice is just trying to say is that at this stage of the argument, so your friend has argued there's no charter violation, right? And we've listened to his argument and we're considering it.